Hello, good afternoon, and welcome to The Law. This is your legal light, and it is your health law. I'm Samson Ladi Anyenini, and this afternoon, once again, we're excited to come into your homes and to share with you the law, empower you in this regard. So, you may have had this contract of employment, you want to get out of it, you want to do something about it, you are not too sure even if you can negotiate it, or the way it's been handed to you, you must take or leave it. What is the contract of employment? We write back to deal with specific matters that you have sent to us, and then help all of you who will call into the show with direct platinum legal advice for free. We'll be right back. You're welcome back. This is the law. It is your legal light, and it is your health law. And as I indicated earlier, this afternoon, we bring you once again platinum legal advice, free of charge. You know, that's what we specialize in. And my guests this afternoon are Lamte A. Apanga. He is managing partner, Prestige Partners. Thank you very much for making time to join us on The Law.
Thank you, Samson.
Great to have you. Also here is a man that we are so familiar with. Anytime we have had issues with industrial matters, labor matters, we have had the privilege of hosting him. He is the former executive secretary, right, of the National Labour Commission. He is Charles Bawadua. He is managing partner, Law Alert Group. Charles, thank you very much for making time to join us.
Thank you, Samson.
Great. So let's go straight forward and look at the Law 101 for today. What are we learning? Here it is. So on the Law 101 today, we are looking at Article 191 of the 1992 Constitution. By the time we are done with this show, if you didn't remember anything, you don't learn anything, learn and keep this in your heart. It might be useful one day. Protection of public officers. It says, a member of the public services shall not be victimized or discriminated against for having discharged his duties faithfully in accordance with this Constitution, or be dismissed or removed from office, or reduced in rank, or otherwise punished without just cause. So we go to our guest for 2 minutes each of education on this provision of the Constitution. Charles, what does this mean? Because we all know that the contract of employment is not one of servitude. If I employ you, I can sack you anytime I want, for reason or for no reason.
Well, that's a bit interesting. There are a lot of intricacies, but back to the constitutional provision.
Right.
You would note that the Constitution, as provided, specifically says public service.
Right.
So it's important to note that this provision relates only to public service. And what it's simply saying is that if you're a public servant, those situations that exist in the private sector where the employer, as it were, could dismiss, terminate without reason, without just cause, you know, of course, I'm using these words advisedly because there have been certain erosions into those legal provisions.
Right.
You know, when it comes to the public service, you cannot do that. Let me say that this provision has been a subject matter of interpretation by the Supreme Court in the case of Theophilus Donko versus the Attorney General, where the Supreme Court was clear when it said that this provision means two things. One, that when it relates to public service, you can be removed using the procedure or the conditions provided for in your conditions of service, or just cause. So the Supreme Court broke it down. Now, we have a document in the public service called the Public Service HR and Procedure Manual that actually regulates the employment of public servants. It provides for sanctions, how a public servant could be removed, discipline, and all that. So what this provision is saying, that unless you have gone through these procedures and there is justification for your dismissal, there is justification for your reduction in rank, then you ought not to suffer such penalties. So this being a constitutional provision is very key and important, and it's very good that public service must know that this provides protection. Actually, this is lifted from the ILO Convention on Protection of Employment, intended to protect employees, especially those in the public service. Let me say that the ILO Convention applies to all workers, but this is limited only to public service. And the argument has always been made, especially coming from labor, that this provision should be expanded clearly to cover private sectors. And that argument is still ongoing.
To cover private sector?
Exactly.
So that even though I'm a private employer, if I employ you, if I have to dismiss you, if I have to reduce your rank, or remove you from the office,
there should be
I must give a just cause.
Yes, that argument is going on.
And the just cause could include?
Will include particularly following proven misconduct, incompetence, and the things that will require an employer to take disciplinary action against a worker.
Interesting. Yes, so what do you say, Apanga? Well, it says a member of the public services shall not be victimized or discriminated against for having discharged his or his duties faithfully in accordance with this Constitution, or be dismissed or removed from office or reduced in rank or otherwise punished without just cause.
Samson, we do appreciate that the nature of public service sometimes require public servants or employees within the public sector to undertake certain roles or jobs that may appear as embarrassing or placing certain persons in bad light, particularly persons who control or have power and influence. And this provision seeks to provide that protection against such victimization or unreasonable conduct against persons whose by nature of their duty may expose some ills or wrongdoings, and those wrongdoings may perhaps end the officers who are culpable or who may have found themselves doing it as having been placed in bad light. And so in order to provide that protection, the Constitution gives us this provision.
So that there are situations where somebody could be asked to do something, they do it, but when it turns bad, the superior tends to blame, the subordinate, the junior officer, and then they are punished for that purpose.
Unduly, yes, for that purpose. Or sometimes they are not even punished, but they are reduced in rank. They remain there, but they are reduced in rank. Or in other situations, they are even transferred. And they're rendered redundant.
As a form of punishment.
As a form of punishment. And we all will appreciate that it's the circumstance that has warranted the transfer.
And the law says you can't do this.
You can't do that.
Unless there is just cause.
Absolutely. I mean, the very recent situation is what we had with the Demnovo issue. I mean, it may not be direct, but one can deduce from the surrounding circumstance of what happened with the investigations of the senior minister and some of the findings he made, some of the decisions he made, and the public outcry that it was particularly a way to punish him or show him where power lies. And this is where the provisions of Article 191 comes to play. Unfortunately, a few attempts to reverse certain decisions did not work. That is a clear example.
So if you are in public office, please look at the Law 101 once again today. We are putting it up so that you look at it again. If you are in public office, take note. A member of the public office, of the public services shall not be victimized or discriminated against for having discharges or his duties faithfully in accordance with this Constitution or be dismissed or removed from office or reduced in rank or otherwise punished without just cause. So please, assert your rights. If you are being punished, victimized, discriminated, reduced in rank, or even being dismissed from office in a public office without just cause, there must be a just cause. Thank you very much. Now, let's move on to our case for today. We have two cases that were sent to us, but we are going to focus a lot more on one. So it's about contracts, and it's about termination of a contract. So it says, I am on a 2-year contract with an accountancy firm. As part of my appointment, I am entitled to a 15 working days leave. In the first year, I secured a 1-day leave to attend a funeral, another 4 days to attend my sister's marriage ceremony, and 1 day off when my residence got flooded. However, before the Christmas break, my boss told me that based on the leave days I took, which he granted, I am not serious with my work and is advising me to resign. In addition to that, he was ready to pay a month's salary for my resignation. I turned him down and assured him of my readiness to work with him, but he is still insisting that I resign. Please, does he have the right to terminate my contract, which has a year more to elapse? If he does that, am I entitled to any compensation? Right. So once again, you are to my immediate right, left. Yes, what do you say?
Well, it's an interesting scenario.
Right.
The situation calls upon us to discuss the law on termination of employment contracts.
Right.
And leave for that matter. The particular affected worker is saying that he has a 2-year contract. He has gone a few days out of work with the permission of the employer.
That's right.
That is very key.
Okay.
With the permission of the employer. That means that there is contract.
Mm-hmm.
And let me say that employment law or industrial relation practice is all about agreement. It's fundamentally the law of contract.
Okay.
So that what the parties agree is what must be carried out by both the employer and the employee. Now, so if per the contract, a certain number of days leave has been given, the employee applies for 1 day off to undertake one assignment, 4 days off to take this, and these were agreed by the employer.
Mm-hmm.
The employer cannot now use that as a basis for terminating the employment of the employee. That will be in violation of the contract. If the contract did not permit it, nonetheless, the employer agreed, that will be an implied amendment to the contract.
Okay.
Because the employer agreed. The fundamental thing is that there should be agreement.
Okay.
So once there is agreement, it is not a basis for termination. You can take it out of the number of days leave that the worker is entitled to. And by law, every worker is entitled to at least 15 days working, 15 days leave.
All right.
Per year. Every worker by law. So if there was agreement based on which these leave days, 1 day off for that assignment, 4 days off for another, the employer cannot, and I have said already, use that as a basis for terminating.
Okay.
Now, if he does, the worker is entitled to claim compensation.
Yeah, that's the question he asked.
Exactly.
And this worker's name, we're not putting all of it in out there. We call him Rich. In fact, he's Rich something. So we use his name Rich. And there are other details that he sent us that reveal, you know, his identity regarding the place he's working and all of that. But for good reason, we have redacted the information.
Yeah. Right. But you see also, the worker also should be mindful that the relationship is for the good of both parties. It's a mutual relationship. So that if you keep taking day out in an unorganized manner, it has the potency to disorganize the employer. And so if you look at the law, particularly 27 of the Act, the Labor Act, it requires that every workplace should have a leave schedule, which should be published at least 30 days to the day every worker is supposed to go on leave, so that you know that in this year, I'm supposed to go on leave in June. I'm supposed to go on leave in August. So that list must be there.
Every workplace must have a leave schedule. And it should be published.
It should be published.
30 days.
Exactly.
To the leave.
30 days. If you look at it, I think it's
so my employer shouldn't just get up one day and tell me,
no,
I think you should go on leave the next weekend.
No.
Okay.
27.1 says that a worker shall.
27.1.
Yes.
Section 27.1 of the Labor Act.
A worker shall, as much as may be possible, be given notice of the date of commencement of his or her annual leave, at least 30 days before the worker takes the leave. Every employer is required to keep a record showing the following particulars. A, the date of employment of each worker employed by the employer and the duration of the annual leave to which the worker is entitled. B, the dates on which the annual leave is taken by each worker. So these are requirements that the employer must keep and publish, so that every worker is aware.
Okay.
So that if you are supposed to go on leave in June, in January you take 1 day off for a wedding, in February you take 4 days off for some other event, and you keep doing that, you are actually disorganizing the employer. And that may be a reason for you having some difficulties with the employer, and thereby kind of putting misunderstanding within the relationship, which ought to be a mutual one for the good of both the employer and employee.
All right. So you hold it on there. There are other aspects where he says the employer is saying he should resign. He's so serious. He should resign, or rather, and then he'll take a month's salary instead. We'll come to that and know what else can be done. Yes, Lamte, what do you say?
Yes, Samson, every employment is a contractual relationship between the employee and the employer.
Okay.
Governed by the terms and conditions of the employment agreement, whether written or oral.
Okay.
It is required that it should be written. However, even if it's not written, it's governed by the terms and conditions that the parties agree on. Then the Labor Act also provides overriding regulation on the nature of the relationship between the worker and the employer. Now, the employee entitlement to leave is enshrined in the Labor Act.
Okay.
It is a right that the employee has. And so the employer cannot withdraw that right. But as my brother has said earlier on, there should be regulation. But the point is, once the employer asks for permission and it was granted,
the employee
asked for permission and it was granted, it cannot be used against him. If the employer knew that at that time he would require the employee to be at post, he ought to have declined the request and ask him to stay at work because he can't find a replacement.
Oh, decline a request. He has a funeral, and funerals mean a lot to us.
It does, but you may either alter the number of days the employee asks for, or ask that he alters his plan to fit in, because there are sometimes you need to make plans for an alternative person to replace the employee when he's away.
Okay.
You may not have been able to undertake such arrangements. We have situations where it's an emergency. We have situations where there are sick leaves, there are emergency leaves, or situations where we call them where there's a loss of a father or a relative or a close relative.
Right.
And then you may have to take an emergency leave. You can understand. But one of the facts he gave is that he took leave to attend his sister's wedding.
Right. That was just for 1 day.
For 1 day.
Yes. It was the funeral that he attended for 4 days.
But even 1 day for the employer's side, also is equally important, because productivity must be must be ensured. He cannot have that day off and then obviously you'll be paid for that day, meanwhile you're not working. So it is a win-win relationship that is regulated by law. The employer cannot turn around, having granted the request for the employee to take those days off, and turn around and say that, no, you are not serious. Second issue is that you do not tell the employee to resign based on the fact that he's taking certain days off. We have rules governing fair and unfair termination, lawful and unlawful termination. The Labor Act section 62 and 63 regulates the nature of termination. If you intend to terminate, you can, but then the Labor Act provides certain provisions and certain requirements. One of the requirements you need to do is not to use the person's leave as an excuse to say that you can't be at work, that you are being asked to leave, and then he's being compelled to resign, in more or less being compelled to resign. This is a situation where you can say there's some amount of constructive dismissal. Okay. Because in this case, he's been asked to resign. It is not his willingness to leave.
Okay, so let's pause there.
Yes.
Guys, explain, what is constructive dismissal? Okay. We hear you, the lawyers, say it a lot, constructive dismissal. Okay. I have taken 1 day for a wedding and 4 days for, is it 4 days for a marriage and 1 day for a wedding? Yes. And you say whatever, I should leave. What is constructive dismissal about it? Okay, so generally termination is when one party informs the other party that I'm unable to work again. Whatever the reasons are, we'll leave that out. Once you inform me in writing that you're unable to work again, that is it. Okay. But where the employer put in certain conditions and situations that require that the employee cannot continue to work anymore, is compelled more or less to leave the workplace. Okay. Is compelled to resign. Is compelled to terminate. Frustrates you from working. Okay. Withdraw resources that you're supposed to work with, take you out of the office and place you in a place where you are redundant, makes the condition of work such a way that you don't feel welcome as part of the team. Some people, their offices are even locked up. Exactly. You can't access your office, the computers you work with has been taken away, passwords changed and you can't access information, or you are even denied other colleagues that you work with, the team that you work with. Yeah. You work in a team and suddenly you've been taken out of that team. All that situation could amount to constructive termination. Constructive termination. Meaning, I didn't get up to leave myself. Yes. I can still say it is my employer who has brought my work to an end. Yes. Even though he didn't specifically write to say, go away. Absolutely. Charles, what would you want to add to that? Constructive termination.
My colleague has vividly explained what it means. Clearly, it's a situation whereby circumstances have been created by the employer to make it impossible for the employee to work. Okay. In such a situation, the employee can himself actually write to say that I'm going and take action against the employer for constructive dismissal. I see. Because you have behaved in a manner such that I am unable to work. You have evinced an intention not to work with me, even though you have not expressly, whether oral or in writing, stated that, please, your employment is terminated or you have been dismissed. Your conduct shows that you no longer want to work with me. Yeah, so I'm the one now writing to say, well, because you have done A, B, C, D, I'm going, I don't want to work anymore. Exactly. It's just like normal case where I resign. When I resign, I'm not, entitled for you to do so much to me. So why is it that in this case, I resign and yet I'm entitled to some compensation and can take you to court? Yes, this is even provided for by the Act. Okay. If you read section 63, subsection 4, it says that a worker's employment is terminated unfairly if then it comes to the relevant section, it says that the worker terminates the contract of employment, right? Because of ill treatment of the worker by the employer, having regard to the circumstances of the case. Okay. So the employer actually takes a pen, writes to the employee, takes a pen, rise to the employer and say that I am.
Guys, zoom your camera on this law.
Yes.
I want the IGP to arrest this man. See what he has done to the book. The whole law, he's torn it into shreds. What is this?
It is evidence of the extent to which this law has been
inside it, he has annotated every section of it. Okay, so yeah, so you were making that point about Rich and what he may be entitled.
Yes. So if the employer continues to harass him with not being serious, he should resign, it may get to a point where working with the employer become difficult. So he'll be compelled to resign. But if he resigns, he would have basis in law to make a case of constructive dismissal against his employer.
Okay.
Because in this situation, it was the employer who actually asked him to resign. Resignation must be voluntary.
Okay.
Resignation must be voluntary. The employee must have decided that I cannot work anymore. And based on the terms and conditions of the agreement, whether to give 1 month notice or in lieu of that pay 1 month's salary, he resigns. And then he serves notice, hands over gently and go. But in this situation where he's being told that to resign, and he's been reminded several times that he has to resign, he can go ahead and resign because sometimes it's difficult to continue working. When the conditions of work is not convenient and it's not comfortable, you can't continue coming to work and having this harassment.
Okay. I had asked that earlier, but we know, and you educate us often, and you say that the contract of employment is not one of servitude. So the employer has the right to decide that I don't want to have you in my place anymore. In the same way that the employee can get up one day and say, look, I'm fed up with this place, I'm gone. So why should the circumstances change?
Well, you see, let me say that the principle of law that you have enunciated to the effect that the employment relation is not one of servitude. It's often added about of service.
Okay.
And so either party is entitled to walk their way. Well, that was the position of the law, but legislation has come in to regulate that. The effect of the labor law partly was supposed to protect the employee, because it's clear that in certain economic circumstances, and especially in Ghana, for example, where employment is very scarce and difficult to come by, some employers have abused this right to terminate without reason and for no cause. And so legislation was made by reason of Section 651, providing in Section 15 the grounds for termination of employment.
Okay.
And the grounds include mutual agreement, incompetence, ill health, gross misconduct. So what it means then is that these are the grounds based on which an employment contract can be terminated.
All right.
In the absence of that, you will now have unfair termination coming in. However, there is a recent decision by the Supreme Court in the case of Georgia Pass versus, I think, Ghana Commercial Bank, in which the court explained what Section 15 meant. The court is saying this, and listeners should listen carefully because this is important, an important area. Where in your contract of employment there is a provision allowing either party to terminate by giving 1 month's notice or salary in lieu of notice, and one party decides to trigger that provision, then you cannot make a claim for unfair termination because it is merely an application of the terms that you have agreed upon by mutual agreement. However, if the termination is for other grounds such as incompetence, gross misconduct, those are matters for which a court of law or the National Labour Commission can investigate to establish the fairness or otherwise of the decision to terminate.
All right.
Now, let me say that we know that in this country, most of the time you are issued with an employment appointment letter. You take it very happy, you decide to accept. And in most cases, this dangerous clause is often inserted therein. And at the point you are seriously looking for a job, you may not have, the courage to challenge such a provision in your appointment letter.
That's right.
So you let it go. The way to go about it is when you have entered the workplace, and our advice is to join a union. What happens is that the unions have negotiated collective agreements. And in collective agreements, there are contained therein procedures by which your appointment can be terminated. Section 19 of this Act says that where in a collective agreement there are procedures for termination which are more beneficial to the worker, then those procedures will supersede the provision in 15 which allows the triggering of mutual agreement.
Okay. Thank you very much. You are here on The Law. This is your legal light. It is your health law. And my guests are Lamtig Apanga, who is managing partner, Prestige Partners, and Charles Baldria, who is managing partner, Law Alert Group, is a former boss of the National Labour Commission. And we are looking at the question of the contract of employment. There is another person who sent us another message, but we will attend to that shortly. That's very briefly. But as you looked at Rich's situation, you gave some education that led me to want to ask, for the purposes of our audiences, what should I look out for typically in the employment contracts?
You would have to pay attention to everything, but particularly terms on termination, leave. Because those are terms that can be triggered at any time, either to your advantage or disadvantage. Okay. And if you don't pay attention to the wordings of those terms of conditions, terms in your employment conditions, it may come back to haunt you.
Just as in his situation,
absolutely,
the question of leave has brought about the question of termination. Okay.
So you need to pay attention, because leave is an entitlement enshrined in the Labour Act.
Right.
The contract of employment may state the number of leaves you are entitled to. You have to see whether it complies with the law, the number of leave. And
so what is given me by my employer in the terms of contract must comply with what the Labour Act says.
Absolutely. You can be given more, but not less. The Labour
law, be giving more than 15 days,
absolutely,
but not less than 15 as the law says.
As the law says.
Okay.
So you are entitled to 15 minimum working days in the labour law. If your employer, based on the nature of your work and the nature of his business,
15 minimum working days of leave.
Of leave.
Okay.
Yes. Minus weekends, minus holidays. Now, because of the nature of work and the operation of the business, the employer may decide that he wants to give you 21 days. Or the position you occupy, you'll be entitled to 21 days or more. That is fine. But you can't be given less. The law does not allow you to give less.
In the public service, we know people who have a lot of days for their leaves.
Yes, in some places, there's a policy that allows you to accumulate your leave. In some places, to the leave, once you don't take it, that's it.
It's forfeited.
It's forfeited.
And that's backed by the law. Right.
Because you are required to take your leave.
Okay.
And in fact, there's even a provision that requires that you can't even sell out your leave. Now, there's this habit where employees sometimes negotiate and then they take some money and continue to stay at work so they don't go on leave. The law is against that.
Okay, you were superintending this whole law. Tell us more about this. That I can't sell my leave days. We all do it. That yes, look, my employer wants it. I want the money, so I take it. Why can't I sell it?
Good. You see, the whole thing about leave is to make sure that the worker actually takes a rest. It's not all about money, and money. The worker needs a rest to be strong, to be active, to be healthy, to be able to continue to work.
Rejuvenate.
And so the law says that any agreement to forgo leave is void.
Void, meaning?
Yes. It means then that it's of no effect.
It doesn't exist.
At all. Okay. Any agreement to forgo leave is void. I think it's section 21.
So in some other terms, for those of you watching us, it means it's unlawful.
It is unlawful.
It means it hasn't happened at all.
Exactly. So and this provision has been the subject matter of interpretation by our courts also, in the case of ADRA and ECD.
Okay.
Where the court, in the opinion of the court said that, look, that is what it means. It means that an agreement to forgo your leave is invalid. However, the court said that where it is shown, in most of this kind of agreement, the employee agrees to take money. The court said where it is shown that the employer actually prevented the employee from going on leave because of the exigencies of the workplace, then even though the law says the agreement is void, the employee is entitled to claim compensation, because it will not be right to use the employee, and when he's seeking compensation, you flag the Labor Act and say, look, all that we were doing was illegal.
Okay.
So that is the view taken by the court.
Thank you very much. So you said we should pay attention to the terms of leave and the terms of termination.
Yes.
How either party can terminate the contract.
Yes. Well, in most employment contracts, it will be stated clearly that either party can terminate by giving 1 month notice, or in lieu of that, 1 month salary.
Okay.
Simple as it is, without giving the basis for termination.
Okay.
And so once there is a term there that allows either party to terminate, you, the employee, can resign by giving 1 month notice. You have fulfilled the requirements of the term. Likewise, the employer. That is why the employer is not required by law to provide reasons for termination. If he does choose not to provide reasons for termination and resort to the term that allows him in the employment contract that he is terminating, once he fulfills the requirement of giving you 1 month notice or pay you 1 month salary in lieu of the notice, it is enough.
Okay. So many times employees have been under the impression that it is only the employer who, when he doesn't give you the 1 month notice, must give you your month's salary, but not the other way around. If you two decide to get out of the employment, as it were, unceremoniously, or very unceremonious means there's no notice. You give a notice, you don't give a notice and you want to go immediately, you must also pay the employer 1 month's salary.
Yes.
Oh, really? Yes. Employees, we don't have money.
You are required to, or else you forfeit your salary for that month.
Okay.
Yes.
Okay. So we want to take a quick break and return and then hear from our viewers as well. But there's something small we will also get your views on. So Rich should do what? He's being asked to resign. He doesn't want to resign. His boss says he should go. What should he do immediately? My
first advice is that he should get his boss to put it in writing. Because he needs evidence to prove that his boss compelled him to resign.
Okay.
What he has told us so far are oral conversations between him and his boss.
Right.
It is difficult sometimes to prove oral conversations in court. He needs some evidence.
Yeah.
So either he finds a way to send an email to the boss to confirm it, or the boss send a memo or some amount of written evidence.
He's gathering evidence.
Absolutely.
Okay.
So that if it continues and at some point he is compelled to resign, he can use that as a basis to justify his claim for constructive dismissal.
Okay. Yes, Charles.
Yeah, so I was just, we were talking about what should be contained in an employment contract.
Right.
Often we didn't look at this, but it's important. There's a certain minimum information that must be provided by law.
Okay.
So if you go to the schedule to the Act, the name of the employer must be there, the name of the employee must be there, the date of first appointment. You are employed as your job title should be there. Your date, method, and intervals of pay. When should you be paid? They should all be contained. Your hours of work must be clearly indicated. Your periods of holidays and details of holiday pay must be clearly shown. The conditions relating to incapacity to work due to sickness or injury and the details of sick pay, if any, are supposed to be indicated clearly. Details of social security or pension scheme. the amount of notice to terminate employment to be given by 1, the employer, 2, the worker also, the disciplinary rules applicable to you, the procedure for dealing with any grievances or dispute at the workplace, overtime payment, if any. So these are the minimum requirements that must be contained in an employment letter or a contract of employment.
Often they are not in the letter.
Exactly. So normally you will have an attachment which says reference to a condition of service document,
all right,
or a collective agreement if there's any.
And we live in an environment where mostly they give you a letter, there are no terms and there are no conditions around.
Exactly. Then you must search out, because these are the basis upon which you can make any claim. If you look at the kind of information they are seeking,
okay,
whether or not your employment has been fairly, unfairly, wrongly, or unlawfully terminated, can be derived from this information if it is contained in your employment document.
Okay.
Otherwise, you have an empty document. Okay. You make a claim. They say, where do you find that in your employment?
Thank you very much. And on that note, we take a quick break. We'll be right back. This is The Law. It is your legal light and health law. You're welcome back. This is The Law. It's your legal lights. It's your health law. My guests are Lamte A. Apanga, who is Managing Partner, Prestige Partners, and Charles Baldua, who is Managing Partner, Law Alert Group, and he's the former boss of the National Labour Commission. We have looked at Rich's situation and pieces of advice giving. We are fortunate, lucky, privileged to have them agree to join us again next week to do a part 2. So I'll plead with you. We can hold on with your questions, put them nicely together, plan them well, and then next week we'll do a second part and go into other aspects. There are some of you who have sent us messages. Some of you have asked us to look at the question of contract in restraint of trade. You are going into an employment and they say you can't do anything apart from this. Meanwhile, you feel that the kind of service you want to provide, you could do it for another place and also earn some money. How do you navigate that situation? There are those who have asked, what about undue influence in the negotiation process? Undue influence. So you are not able to ask for what you are due, and you are going in, it's like you need a job badly. So you take it, whatever it is, you take it. If you take it that way and something happens, what else can you do in future? We'll deal with all of these. So thank you for your patience. So Charles, what exactly should he do? He's saying, I don't want to resign. He says I should resign. Can I get compensation if I'm forced to resign?
If I am to advise Richard, I would advise that he resigns and takes action for constructive termination.
Right.
The thing is this: if you don't resign, he will terminate your employment anyway. And once you are holding a termination letter, it will be more difficult to get a job holding a termination letter in another company. Those other companies may not be interested in what happened. You will not have the opportunity.
Okay.
All they ask is your employment history. I was working in this accountancy firm and they terminated my employment. Why did that happen? You will not have the opportunity. So whether you terminate for constructive termination or the employer terminates, the result is the same. You can always take action against the employer for wrongful termination or constructive termination. I would advise him to resign, but take action pursuant to the provision I've read in the Act, Section 63, which allows the worker to do that.
But he should find a way, like Lamtin said, find a way to preserve the evidence of the compulsion on him to resign.
That is important because you need to show that these were the circumstances under which you resign.
And it shouldn't be your word against his word.
If it's a word against your word, you may not succeed. Because on the balance, as we know in evidence law, you should be able to show that your story is more probable than that of the employer.
All right.
And you do it when you have the evidence to show. The evidence may be oral. If you have colleagues who are prepared to testify, and there's documentary evidence to that effect, then you can make a case. It's better that way than to wait for the employer to terminate your employment.
All right.
And now tarnish your, reputation, and for which you may find it difficult to get another.
Prospects of future employment.
Sure.
And Rich, truth is, if you don't take a step, and he doesn't take any step immediately, the atmosphere within the workplace, you can't even survive it. Because you are working for him, your superior, and he doesn't want you in the place, in the space. It just doesn't work, correct?
That's true.
You see, if it were a public service, then Article 91 will come in.
Okay.
You could now rush to court, you could go to National Labour Commission to get a declaration and to restrain the employer. But this is private, and it's just for 2 years contract. So your possibility of even your contract being renewed, is in danger.
Almost.
Okay.
Yeah.
Thank you very much, gentlemen. Well, we have the next other issue that was brought to us, but we think that we can safely preserve it for the next session. There's a colleague lawyer who also sends a message which is critical I want to share. He says, employment contract is a special kind of contract which labor laws have made specific inroads to protect the employee. Normally, employment laws such as the Labor Act have made special considerations to protect the worker who is considered a weaker party to the employment contract. Employers must be careful with the terms of the employment contract in order not to contradict the act to their own detriment. You said they should ensure that what they are seeing in the terms complies with the act. So this is what Ernest is advising. It says again, employers should be careful to ensure they meet the minimum provisions of the Labor Act because the courts or the National Labour Commission is likely to favor the employee in any dispute. So to employers, don't even wait for the employee to point out things to you and insist on things. For your own good, make sure the terms you are giving to the employee meet the minimum requirements of the Labor Act. It's for your own good. What would you say to that?
Well, I think it's a proper expression of the law. There is no doubt the fact that the employee is the weaker partner in this relationship.
Right.
It is for that reason that legislation has been made to, first of all, protect the employee from abuse by the employer and to provide minimums. And let's be very clear that what is in the Labor Act are minimums and not maximums.
All right.
So you can have conditions that are more beneficial to the employee in your contract of employment. We gave the example of leave. The minimum, the law says, a minimum of 15 days. You can give 30 days.
And those 15 days must not include weekends and holidays.
And holidays. You can give 30 days. And so I believe that if employers are properly advised and workers are equally properly advised on the provisions of the Labor Act, the minimums that it provides, and both parties observe, I'm sure that we would have a harmonious industrial relation in this country, rather than the daily terminations, the dragging to National Labour Commission, the dragging to court, the strike action, and what have you.
Right. And you said something that minimum, the contract should be in writing.
In fact, the law requires that it should be in writing.
Right.
That is the requirement of the law, the Labor Act. But even beyond that, where you fail to do that, the challenge is that how do you prove the terms and conditions that governs the labor relationship? And so if you fail to comply with the Labor Act, you would have challenges to prove the terms and conditions, particularly if you want to rely on them. So it is always safe to be on the side of the law, let it be in writing. Sometimes you are so desperate to get a job, and so you've been offered a job, but after a while, request for appointment letter from your employers. ask them to give you an appointment letter, because without that, it becomes difficult. And it's also a requirement that they should do it. So they're supposed to do it.
Okay.
Mind you, the essence of the Labor Act is to ensure that there will be some industrial harmony for the mutual benefit of the employer and the employee.
Right.
We should pay attention that they are not parties of equal. The employer seems to have an upper hand.
Right.
He's the one making payments.
That will beautifully connect us to the question of undue influence.
Yes.
And God willing, next week we will deal with that aspect, and also contract and restraint of trade, because these days people have so many, expertise, and they don't want to stay to one place. So why do you give them an employment and say, you must do here, you shouldn't go to another place, or you shouldn't do this elsewhere? One of our own law teachers, Prempe, has sent a message, but it's a message that you have dealt with already. Thank you all so very much for keeping your channels here. And this has been The Law with my guest, Lamte A. Apanga, who is Managing Partner, Prestige Partners, and Charles Baudouin, who is Managing Partner, Law Alert Group, and is a former boss of the National Labour Commission. I'm Samson Ladi Anyanini. This is your Legal Lights. It's your Help Law. We'll come your way next week with another edition, part 2 of this, and we'll take your messages as well.